Ms. Hany, so?
Mr. Speaker, thank you for allowing me to speak on this Women's Charter Amendment Bill. I would first like to declare that I'm a practicing lawyer and a member of the Law Society's Family Law Practice Committee 2022. According to the Holmes-Rahe stress scale, divorce is one of the most stressful events in one's life, second only to the death of a loved one. This finding is unsurprising, as part of the divorce process involves parties coming before the family court to end their marriage and address how their most private family affairs will be restructured. More often than not, the contentious divorce proceedings can prove to be emotionally charged events for embroiled parties, overriding rational thinking and clout judgments. Unfortunately, the children are usually not spared from the effects and stresses of their parents' divorce, even though they are the most innocent parties in these matters. There are ways to make the entire divorce process less strenuous and be minimally impactful for our little ones, if everyone is on the same page. As what the presiding judge of the Family Justice Courts, Justice Debbie Ong, has shared in her work plan speech in 2020, the Family Justice Courts and the family justice community will be co-creating a renewed vision of family justice informed by the principles of therapeutic justice. It is hoped that our collective efforts would help to engender a mindset shift in the community. The resolution of family disputes need not be an adversarial one and should be focused on solutions. I therefore speak in support of this amendment bill, as I am hopeful that several of the changes that will be brought about from the passing of this bill would encourage parties to work out their marital differences, lessen the acrimony of court proceedings, and foster parties' cooperations towards co-parenting their children post-divorce. This will be beneficial to the affected children, as studies have shown that the level of acrimony during a divorce proceeding has a perceptible impact on child's well-being. Children should not be expected to take sides and be caught in conflict of loyalty. Instead, they should continue to embrace by both parents with love and attention, regardless of their respective marital statuses. John Bowlby's attachment theory asserts the notions that children need warm, consistent, and responsive caregivers to form secure attachments. Interruptions and interferences in the attachment formation years can have long-lasting impact, resulting in insecure attachment styles. We often hear of stories of parental alienations, where a parent would refuse the other party from having access to the child as a result of hatred or as a retaliation of a deprivation of maintenance by the other party. There are also situations where the child has rejected one parent's request for contact so as to appease the other parent whom they are residing with. The new Section 126B, in relation to the enforcement of child access orders, empowers the court to order inter alia for the parties to attend therapeutic programs or counselling, in the hope that the hostility between parents can be better managed and that the child is spared from choosing sides. I believe that these sessions will take place at the divorce support specialist agencies. In this regard, I wish to seek clarifications on whether there are any fees applicable and payable by parties for participation in such sessions. Currently, the supervised exchange or supervised visitation programs ordered by the court to take place at the DSSAs for the first 3 court orders are free of charge. From the 4th court order onwards, however, the parties will have to pay for such services at the DSSA. Visitations, which will be supervised by counsellor on a Saturday at the DSSA, will cost $240 per hour. There are presently 7 family service centres and DSSAs located across Singapore. By the end of financial year 2020, 2022, there will be 10 regional centres available to support families in need. In view of the increased support, would the Ministry consider increasing the number of complementary sessions for parties to carry out the supervised access at the DSSA? Also, would the social service agencies be able to provide more hand-holding services to closely monitor the education and welfare of the children during and after their parents' divorce, so as to prevent the possibility of delinquency and other potential social complications? As what Mr. Lim Biow Chuan has shared earlier in his speech, in order to file for divorce in Singapore, one has to first persuade the court that the marriage has irretrievably broken down by citing one of the facts, either fault-based or non-fault-based, as set out in Section 95A of the Women's Charter. Currently, parties who are unable to fulfill the requirements to file the divorce based on the non-fault-based facts are nevertheless required to cite facts blaming the other spouses as the cause of the breakdown of the marriage, even when both are cordial about ending the marriage in the first place. The new amendments, which introduces a sixth fact termed a divorce by mutual agreement of the irretrievable breakdown of the marriage, may be a new solution to those parties who are in mutual agreement to dissolve the marriage. Under the new fact, couples are to take joint responsibility for the breakdown of the marriage and will have to include, amongst other reasons, the reasons for the marital breakdown in their submissions to the court. In this regard, I hope the Ministry can elaborate on what type of reasons are deemed as acceptable to substantiate that the marriage has irretrievably broken down under the new sixth fact. I understand that MOS has shared earlier that parties may cite examples of their deep-seated differences so as to substantiate this fact. In this regard, I hope that the particulars to be mentioned to support this fact need not require parties to cite each other's misdeeds, as that will require them to rehash their marital disputes all over again. In my opinion, this do not assist in reducing the acrimony between parties. Moreover, I do hope that parties should avoid attributing the children as the reasons for the breakdown of the marriage. Children should not be made to feel that they are the cause of their parents' divorce. As mentioned earlier, divorce does have long-term effects on children. Social science research have shown that feelings of guilt, abandonment, and shame have adverse impact on child's physical and mental health development. Under the new sixth fact, the parties will also have to show efforts of marital reconciliations. I support the inclusion of this requirement, especially when children are involved. During the Family Justice Practice Forum 2020, Ms. Audrey Siew, then Director of Family Support Division of MSF, shared that an intergenerational study was conducted in 2020 to examine the long-term impact of divorce on children. Compared to children whose parents were not separated, children from divorced families are less likely to complete university, may earn comparatively lower salaries, and are more inclined to remain single and are predisposed to divorce if they were married by the age of 35. Apart from illustrating the reconciliation efforts, the parties will also need to set out the considerations that they have made for their children and the financial affairs in their submissions to the court when filing under the sixth fact. In this regard, can the Ministry clarify if this means that this fact can only be relied upon when the divorce is filed under the simplified tract, where parties have agreed on all issues relating to the divorce and the ancillary matters? There are situations where a divorce filed in an acrimonious manner, for example, on the basis of the defendant's unreasonable behavior or adultery, has since seen both parties subsequently undergo mediation at the family justice courts, during which marital reconciliations was explored but failed. However, these parties have in turn reached an amicable global settlement on the divorce and ancillaries through the mediation. In this case, could the courts allow for the divorce to be proceeded on an uncontested basis on an amended claim under the sixth fact? There is a Chinese saying, 家家有本难念的经. Every family has its own challenges. Families who are involved in litigation often come with complex needs and issues. Underlying many of these family disputes are non-legal related concerns. As such, I echo the need for collaborative, holistic, and multidisciplinary interventions be used to address the family's underlying dysfunctions and emotional needs whenever possible. More importantly, we should prevent the children from feeling distressed while in the midst of their parents' divorce proceedings, bearing in mind that such an adverse experience can have a lasting negative impact on their lives, lasting far into adulthood. In conclusion, Mr. Speaker, notwithstanding my request for clarifications and suggestions, I stand in support of this amendment bill.